Manager at the National Women's Law Center. I'd like to thank you for joining us for today's webinar. We have just a few housekeeping notes before we begin the presentations. First, all lines will be on mute during today's webinar. We will be taking questions after our experts are finished with their presentations, but we encourage you to submit questions throughout the webinar. You can submit a question by typing it in the designated area on your control panel and hitting send. We will be recording the webinar, and you will receive a link to the recording of the presentation, as well as a link to the PowerPoint slides and additional resources within the next couple days. Finally, please note that this is a webinar intended for advocates and those interested in the subject, and is not intended for press purposes. At this time, I'd like to turn the floor over to Lara Kaufmann, Senior Counsel and Director of Education Policy for At-Risk Students at the National Women's Law Center. Lara, take it away.
Thanks, Amanda, and thank you everyone for being on today. We are so excited to have this opportunity to connect with people and go over an area of the law that is often confusing and technical and complicated, but is so important, and this issue is really important in the lives of students and others at schools. So we're really glad to have with us Dana Bolger, who is a fantastic advocate. She is the founding co-director of Know Your 9, a national grassroots campaign that educates students about their Title IX rights and demands improved federal enforcement of those rights. Dana is also a writer at feministing.com, and she's testified before Congress on sexual violence policy and legislative reform. Her writing on this subject has appeared in a number of outlets, including the New York Times, USA Today, MSNBC, Al Jazeera America, and The Nation. We work closely with Dana on a number of things, and we're really excited to have her with us today because she can really give another perspective on what's going on college campuses. She's going to share with us some stories about what schools are not getting right, and she's going to talk to us about the organizing work she does and organizing on student campuses. So I'm thrilled that she's with us, and as Amanda said, I'm the Senior Counsel and Director of Education Policy for At-Risk Students at the National Women's Law Center, and I oversee some of our work on sexual harassment and sexual assault in schools, and really glad to have everybody on today. So I want to just let you know what we're going to talk about. We're going to talk about the basics of Title IX as it applies to sexual harassment and assault. Of course, Title IX is much broader than that and touches a number of rights that students have. And we're also going to talk about some of the legal options that are available to survivors and even get into some specifics on how to file a complaint with the Department of Education's Office for Civil Rights. If you think your rights have been violated or you think your school is not complying with Title IX, there are a number of different ways that you can try to address the situation. And throughout this webinar, we're going to try to talk about that and the ways that some of the legal requirements differ, and we're going to talk about legal action, but we're also going to talk about student organizing. So there are a number of different routes you can take. Before we get started, I wanted to do some polling. We wanted to ask the audience a couple of questions. Amanda, can you go ahead and put up those polling slides? So one question we have, and I don't know if people can see the polling questions. Okay, the first question was, what is your background? Are you a student? Are you an educator? Are you a service provider? Are you an advocate or other? And I recognize that some people fall into multiple categories, but if you could just pick the one that's primarily your identity right now, that would be great. And it looks like there's about an equal split between advocates and educators, and then we have a quarter of people on the call are under the other category. Looks like 36% advocates, 32% educators, 14% service providers, and 8% students. So that's the makeup of our call today. And the second question is, how familiar are you with Title IX? We want to get a sense of people's background. Are you somewhat familiar, not at all familiar? Are you very familiar, or are you in fact a Title IX professional who works on this and talks about it as much as I do? So it looks like at least half of our audience is somewhat familiar. 28% consider themselves to be very familiar, 19% are Title IX professionals, and then we have 6% who are not at all familiar, actually 7% now. So that's good to know because some people will need more background than others. But we are going to really, because there's so much to talk about and we don't have so much time, we're going to talk about things at a pretty broad level, and there'll also be time, of course, for questions and answers. So the basic what is Title IX? It's a federal law that is made up of 37 words and prohibits sex discrimination in education. That applies to any schools that receive federal funding, including K-12 schools, including colleges, many private schools. It's not just public schools. And if a student receives federal financial aid to go to a school, then that school is a recipient of federal funding for Title IX purposes. So that's important to know. Another thing is that the ban on sex discrimination includes sexual harassment and sexual assault, which is why we're here today. And it applies to anyone on a campus or at a school, including students, employees, someone visiting the campus, and it doesn't matter what their sexual orientation or gender identity is, their immigration status, or their disability status. It applies to everyone. It says, the law says no person shall be discriminated against. I'm trying to advance my slides. Okay. Definition of sexual harassment is unwelcome conduct of a sexual nature. And that can include verbal, nonverbal, or physical conduct of a sexual nature. It doesn't have to be, obviously, a request for sexual favors or physical groping. It can be more than that. But certainly that kind of conduct, which is what we're talking about today, is going to be covered. Sexual violence is an extreme form of sexual harassment. We think of this activity as a long continuum. And a lot of times, sexual harassment that's not addressed can ultimately end up with an instance of sexual assault or a pattern. And unfortunately, survivors of sexual assault oftentimes experience sexual harassment or retaliation once they come forward with their complaint, and that is also prohibited by the law. So there really is a continuum here. Sexual assault is physical sexual acts done against a person's will or when a person is incapable of consenting, and that includes situations when someone is unable to consent because of drug or alcohol use. And OCR, I'm going to be referring to throughout this presentation. OCR is the Department of Education's Office for Civil Rights. It is the primary federal agency that enforces Title IX. The Department of Justice also works on these cases. The OCR handles complaints that individuals and groups file. It also does compliance reviews, looking at school policies and practices to see whether they're complying with the law, and it helps schools understand their legal obligations, provides them with technical assistance. So the reason that this is a violation of Title IX is because students have a right to an education free from discrimination based on sex, and unfortunately, when a student is a victim of sexual assault, very often she is not able to continue her education and no longer has that access to an education free from discrimination on the basis of sex, particularly if she's experiencing a hostile environment, which is something we'll talk about in a moment. Title IX focuses on the school's responsibility to ensure that everyone has equal access to education. It is different from criminal laws and civil laws, which will look at the responsibility of the accused and the perpetrators. And those, obviously, civil and criminal cases lead to an investigation, penalties, and possibly jail time, whereas the school, when we talk about Title IX cases, we're talking about what is the school's liability, what is the school's responsibility to protect students, to ensure their students do not have to go to school in a hostile environment. The Clery Act, many of you may have heard of, and I just want to clarify, it's separate from Title IX, and it's really a campus crime statistics bill. It requires schools to report statistics on campus crimes. But it also says that schools have to publish an annual security report that includes a lot of information that I'll get to in a moment. They have to make those statistics public, and really recently, the Violence Against Women Act amended the Clery Act and added some more requirements for schools to publicly report on, which will help increase transparency and help students and families and communities get a better sense of safety on their campuses and how their campuses handle these types of incidents. So under the Clery Act, schools have to report about what prevention and education programs they have in place, what types of grievance procedures they have and disciplinary procedures, what is their policy on confidentiality and confidential reporting, and what victim services they offer, among other things. Those are just some of the highlights. And in the fall of 2014, several months ago, the Department of Education issued a set of regulations that implement these changes in the law. Those rules were developed through a negotiated rulemaking process. There was a rulemaking panel that was made up of students who are survivors of sexual assault, as well as representatives from advocacy organizations like ours, law enforcement representatives, representatives from colleges, and other groups. And through that rulemaking process, these rules were developed, and there was a public notice and comment period, and the final rule, as I said, was developed last fall. So let's talk about what schools' obligations are. Whether a report of harassment or assault has been made or not, there are certain basic steps that schools have to take under Title IX. They have to have a notice of non-discrimination to all students, and it has to be distributed and posted on websites or in handbooks, things like that. They have to designate a Title IX coordinator and make sure that the school community knows how to reach that individual or individuals. Depending on the size of the school, they may want to have more than one Title IX coordinator. But every recipient of federal funding must have a Title IX coordinator whose job it is to receive Title IX complaints, to oversee the school's compliance, to oversee the resolution of those complaints, to identify any patterns or systemic problems in the school's compliance and to address those patterns, and generally to help educate the school community about their rights under the law and educate the school about their obligations. So it's a very important role that has been neglected for a long time in certain schools, particularly at the K-12 level, but it's something because of all the recent activity and investigations that schools are taking more seriously, and that's a good thing. The school, in terms of the notice of non-discrimination, they don't have to have a separate policy that prohibits sexual assault, but the school should make it clear that that type of conduct is a violation of Title IX, and the school needs to be aware of this. The students need to be aware of what kind of conduct constitutes sexual assault, and that conduct is prohibited. Schools have to have and publish grievance procedures for handling complaints of sexual assault, and we'll talk about those in a little more detail in a moment. School employees have to be trained on how to recognize and report harassment, and students should get that training as well. And schools are supposed to be monitoring campus safety through good record keeping and periodic assessments of the campus climate so that they can get ahead of the problem. Now, the grievance process. There has to be a grievance process in place to resolve complaints. It doesn't have to be a grievance process just about sexual assault. It can be for all Title IX claims, but there should be a grievance process in place, and schools should make students aware of it by widely distributing it, explaining very clearly how to file a complaint, what to expect when you do file a complaint. And the school's resolution of that complaint has to be prompt and equitable. And in terms of what prompt and equitable means, we'll get to that in a moment. When a school becomes aware of an incident, the school has to take certain steps right away, even if it is not going to conduct an investigation or if the investigation has not started yet. And let's talk about what those steps should be. They need to provide the survivor with information on the fact that she has a right to file a Title IX complaint and how to do so if she chooses. They also should tell her that she has a right to report the incident to the police and how to do that if she so chooses. That does not mean that they can force her to go to the police or force her to file a Title IX complaint. They should just make those options, make her aware of those options. They also should make her aware, and when I say her, I mean generally I know men are also victims of sexual assault. They should also make survivors aware of the services that are available to them. They should offer accommodations that do what they can to ensure that the survivor feels safe. And again, they do not need to wait until an investigation is open to do that. In fact, OCR has been very clear that a school cannot require somebody to file a complaint in order to access services or accommodations. They need to make those available to survivors even if the survivor decides not to pursue a formal complaint. They also need to, in making those accommodations, they should try to minimize the burden on the survivor. And what that means is if two students have a class together and one student reports a sexual assault by the other, and it's uncomfortable for her to continue going to that class and sitting in the same room as the perpetrator, then they need to figure out a way for her to feel comfortable and go to school safely and minimize the burden on her. So telling her to drop that class is not, excuse me, I'm recovering from the flu. Telling her to drop that class is not, cannot be their first move. They need to figure out a way to ensure that she can still go to that class and perhaps have the other student drop the class, or find a way for the other student to take the class remotely, or there may be a number of solutions, and it depends on the circumstances. Similarly, a survivor of sexual assault should not be forced to move out of her dorm and turn her life upside down just because she just experienced sexual assault. We don't, we want to ensure that students feel safe, and it should be up to the student whether, obviously if she wants to do that, move out of her dorm, for example, that's something that should be an option for her, but there should not be an assumption that she has to bear all the burden of this process. Confidentiality is a very, very important issue. A lot of schools get confused about this, but one thing that's very clear is that schools have to be very upfront with survivors about who will keep their complaints confidential and who will not. There's a lot of confusion out there, and students, unfortunately, have been told that their complaint would be kept confidential and then have found out that it was not, and a disciplinary process starts. They don't even want to be part of that process, and that's not in anybody's best interest. So school counselors, of course, and victim advocates may have their own professional obligations to keep conversations confidential. There are some school employees called responsible employees under Title IX who have to report information to the school about a complaint, including identifying information about the complainant and about the alleged perpetrator. And the way responsible employee is defined is somebody with the authority to do something about it, somebody who has a duty to report. I mean, there may be a way that schools are defining certain faculty members, for example, as having a duty to report incidents when they hear about them, and anyone that a student reasonably believes would have a duty to report. So, what the concern here is that school will try to escape liability by designating only one person as a responsible employee, and if you report your assault to anybody else, you will not get any kind of services or relief, because we've seen that happen. And I would say particularly at the K-12 level, what we've seen happen is students report to their teacher, for example, that something happened, and it will never get reported up to the principal, or it will eventually get reported up to the principal. But what the school has said in court is, sorry, you didn't report to the right person. And courts have actually defined responsible employee narrowly, but OCR has been very clear that responsible employees has to do as well with a student's perception of who is responsible to report that up. So schools need to make clear to students what a person's obligations are before she reveals confidential information. Once she has made a report, the school is still required to maintain confidentiality to the greatest extent possible. And it may not always be possible, and they need to talk to the survivor about what their constraints may be. When a student files a complaint with the school, and we're talking about whether the incident was on campus or off campus, the school has to promptly investigate. So as soon as the student says, I want to initiate an investigation or a Title IX complaint process, the school has to act promptly. And if they learn from the investigation that the conduct has created a hostile environment, they have to take immediate and effective action to address the problem. So let's talk about what that means. Well, we'll get to the definition of hostile environment in a minute. I think first we should talk about the difference between a school investigation and a police investigation. The school has to start an investigation, and it has to be prompt, thorough, and impartial. And that is true even if the police are conducting their own investigation. So as I said earlier, there's no requirement that schools cannot require a student to report her assault to the police. And they need to start their own investigation if that's the route that the survivor wants to go, or if they determine it's absolutely necessary for the campus safety. And even if the police are conducting an investigation, that may give the school some reason to delay its investigation, but it cannot wait for the outcome of the police investigation before they start their own investigation. And if the police don't press charges, they can't use that as an excuse to abandon their own investigation process. They still need to proceed because the school process is looking at different factors than a criminal process and is applying a different standard of evidence than a criminal process. Under grievance procedures, there are certain minimum requirements that OCR has set forth. Schools have to disseminate information about the process and how to file, and resolve complaints in a way that's adequate, reliable, and impartial. I know those sounds like legal mumbo jumbo, but here's what we mean by that. School officials that participate in the process have to be trained on dealing with victims of trauma, on what the law is on sexual harassment, and they have to be impartial. And the parties have to be treated equally. So they have to have an equal opportunity to present evidence, including witnesses, and they have to have equal access to information that's going to be used at a hearing. If one party is given a right to appeal, the other party needs to be given a right to appeal, and the other party needs to be notified that the first party is appealing. That's the kind of thing OCR has said there's no requirement that schools provide an appeal process, but if they do, it has to be offered equally to both sides. Questioning about the survivor's sexual history with anyone other than the alleged perpetrator is not allowed. And the standard of proof is the preponderance of the evidence. And what that means is that a disciplinary proceeding has to be decided based on whether it is more likely or not, at least 51% likely, that the alleged conduct occurred. In a criminal process, you would have to find guilt beyond a reasonable doubt, and there's a reason for that because the deprivation of liberty that can result from a criminal process is extremely severe, and those are some constitutional protections that are in place for criminal procedure. In this process, which is a school disciplinary action, the standard of proof is whether or not you can prove by a preponderance of the evidence that the alleged conduct happened. A higher standard of proof, like clear and convincing evidence, is not the appropriate standard. In terms of time frames, schools are supposed to notify the complainant of what the time frames are at all the stages of the complaint process. So you should notify a complainant of how long it will take to complete a full investigation, and OCR really wants these investigations to be completed promptly. They say that 60 days is about average, that they recognize that in certain circumstances it could take longer or it could be quicker, but they use that number as a guide. They need to tell the complainant when they will inform both parties of the outcome and what time you have to appeal if that's an option. And the school has to inform you in writing of the outcome and give you any information that's necessary to remedy your hostile environment and protect further harassment. And so what that means is some schools may try to hide behind FERPA and say that they can't reveal student records, so they can't tell you what disciplinary action was taken against a perpetrator. And you know, it's not that simple. What OCR is saying is if disciplinary action is taken that directly relates to the survivor and that the survivor needs to know about in order to feel safe going to school and continuing her education, then that information has to be provided. The school also has to take steps to prevent the harassment from recurring and remedy its effects. So in terms of legal options, if you think your school is not in compliance with Title IX, there are a number of different options, and I think Dana will talk about some of the non-legal options. But one thing to do is to go to your Title IX coordinator or write a letter to your school pointing out the ways in which it's not in compliance with Title IX. Of course, another option, though, is to file a complaint with OCR, and you don't need a lawyer to do that, or file a civil lawsuit in federal court. Now, in order to file a lawsuit, you have to be the person affected by what you're alleging. So you yourself would have to be the survivor whose school did not do what they were supposed to do in order to have standing to go into federal court and sue. But for the Department of Education's Office for Civil Rights, if you think your school is out of compliance, even if you personally were not harmed, you can still go in and file a complaint and ask the Department of Education to investigate. So now, what is a hostile environment? The reason I wanted to wait until now to talk about this is because it's directly related to your legal options. The standard or the definition of hostile environment is different in federal court than it is. It's different in federal court when you're seeking money damages. So let's talk about what that means. If you're just filing a complaint with the Office for Civil Rights, or you're bringing a lawsuit against your school, but just in order to get the school to change its policies and you're not seeking money damages, then here is the standard. The standard is whether sexual assault and sexual harassment is severe or pervasive enough to interfere with a student's education or their participation in any school program or activity. And OCR has said that one incident of rape can be severe enough. It doesn't, you know, that may be enough, and you don't need to show that there were multiple acts. If we're talking about less serious harassment, sometimes if there's a pattern and it's pervasive, that will be enough to show that a hostile environment exists. And when you're filing a complaint with OCR, the remedies that they can provide are varied. So one thing they can do is ask your school to enter into, if they find a violation of Title IX, they can ask your school to take steps to come into compliance, and they might enter into something called a resolution agreement where they will lay out all the steps that your school has to take in order to conclude the investigation. They also may award some monetary compensation to you depending on how you've been affected by what's happened. And so that is one route, but it's limited, and it won't provide the same sorts of remedies that you could get if you file a federal lawsuit. And if the reason this is so complicated is because of a Supreme Court decision from 2007 that set out this higher legal standard for money damages cases. So if the answer to question 1 is yes, and there is a hostile environment, and the school knew or reasonably should have known about the harassment or assault, then the school will be liable if they don't take action that are reasonably calculated to end it, to remedy its effects, and to prevent it from recurring. That's important. In the OCR process, or when you're just bringing a lawsuit for injunctive relief, which means you're trying to get the school to do something to change its policies, then the issue is whether the school knew or should have known about it, and did it take effective action. But if you're trying to get money damages in court, the standard is different. The court's going to look at whether the harassment was severe, pervasive, and objectively offensive, so much so that it interfered with the student's education. And the court is also going to ask whether the school had actual notice of that hostile environment and acted deliberately indifferent to it. So instead of asking whether the school knew or should have known about it, they're going to be looking at whether the school had actual notice, and that's where we get into what is the definition of a responsible employee, and did you report it to the right person? And did the school act deliberately indifferent to it? And unfortunately, courts have defined that narrowly. And we have a couple cases pending in court right now where we're trying to flesh out what they mean by deliberately indifferent. In terms of a complaint with OCR, as I said, anyone can file one. You do not have to be the aggrieved individual. You have to file it within 180 days of the date of the most recent harassment or assault or the end of your dealings with your school. And that requirement can be waived if you can show good cause, and that is up to OCR's discretion. And there's a whole rule they have about how you show good cause. With some narrow exceptions, your complaint will be confidential, but you should know that anyone could file a Freedom of Information Act request, and eventually, not while the case is pending, but later on, get a copy of the complaint, although it should be redacted without your identifying information. And retaliation is prohibited. So if you file a complaint with OCR, or even if you just complain to your school about a possible Title IX violation, the school is prohibited from retaliating against you, and the school has to protect you from retaliation by other students or faculty, etc. Unfortunately, we know that's often not what's happening. If OCR decides to investigate your complaint, it will notify you, and it will ask you for any evidence you have. They will probably interview you over the telephone if you're not in the same city as the OCR office. There are 12 regional offices, and you would file it with your regional office, and all of that information is available online. Ultimately, what OCR will do is, as I mentioned earlier, they'll either enter into a resolution agreement with the school that lays out what the school's going to do about what OCR found, or they will issue a letter of findings. The letter of findings may say that, well, we had some concerns about X, Y, or Z, but we don't think there was sufficient evidence to find a violation here. But what you hope would be that, excuse me, that OCR would in fact find a violation and come to a resolution with the school. Unfortunately, complainants don't have a lot of control over that resolution process. And so it's possible that the OCR office will be negotiating with the school and would not really include you in those conversations because they don't have to. And so I just encourage people who file complaints, once you find out who the assigned investigator is, to check in with the investigator. If you don't hear anything for a certain period of time, make sure you check in on where the process is and make it very clear to OCR what remedies you would like to see in a resolution of this case, because they need to be thinking about what will help you as well as what will technically bring the school into compliance. The OCR process can take a very long time, and in theory it should be faster than filing a court case, but we have had some OCR complaints that have taken years to resolve, unfortunately. But they try to resolve cases within 180 days, and they are trying to resolve cases of sexual assault even more quickly. And you have 60 days in some circumstances to appeal the decision, but there's very narrow grounds on which you can appeal. So as I said, the voluntary resolution agreements are one thing that happens. Once that comes into place, OCR will monitor your school for a period of time. There is a process called early complaint resolution where you can try to, OCR can mediate and try to negotiate a resolution before the investigation happens. It's voluntary. You cannot be forced into that. And you can reject the outcome if you don't like where it ends up. These are tips for filing the complaint, and we are going to send this PowerPoint around to all the participants of this webinar. I don't want to take any more time to talk about the details of what to explain in your complaint, what to include, because that's all here, and I want to make sure we have time to hear from Dana about what schools are getting wrong. But here, there's also some things about filing a lawsuit. I strongly encourage you, if you're going to file a lawsuit, to consult with a lawyer, because the burden of proof is very high, and it's also expensive and time-consuming process. And here's some resources and our contact information, and we do take intake from people. We do not have the resources to represent everyone who contacts us, but we try to, if we can't help you ourselves, to refer you to other lawyers who may be able to help you or to provide you with useful information and resources so that you can advocate for yourself. So with all of that said, I will now turn it over to, I think it's going to Dana's screen now, yeah. Take it away, Dana.
Hi, everyone. I'm just flipping through. I hope everyone can see my screen. Hi, everyone. Thanks, Lara, for all of that. That's so helpful. It's a real pleasure to be on this webinar. I used to intern at the National Women's Law Center when I was in college, and so it's really wonderful to be doing this with Lara. As Lara said, my name is Dana Bolger. I am a co-founder and co-director of Know Your 9, which is an entirely survivor and youth-led campaign to end sexual violence on college campuses and beyond. Flipping through a little too fast. Know Your 9 really operates on two different levels. We both try to bring the law in sort of all its complexities down to students and survivors on the ground and distill sort of the key points and rights that students need to know in order to stand up for themselves and their friends on their campuses and make sure that they are enjoying their full right to education under the law. And then we also work to bring student and survivor voices up to the national policy-making level to really ensure that the people most affected by these laws and policies are also the ones who are shaping their future. And so a key part of that work is that we work with the Department of Education to better enforce Title IX. So in the summer of 2013, we held a protest outside of the Department of Education in which survivors from all across the country came and demanded increased transparency around the investigations that the department was doing, as well as around the findings and resolutions at the conclusion of those investigations. We were also asking for speedier investigations. As Lara pointed out, these investigations often take upwards of 3 or 4 years, although OCR has promised to do that much more quickly now. And then we were also asking for better enforcement of the law. So we were very excited to see, after that protest and many meetings later, that the department did finally, last April, release the list of then 55 colleges and universities under investigation for Title IX violations. And of course that list has increased dramatically to, I think, 95 or around there now. So that's a little bit about our work. Lara asked me to speak a little bit about myself and what brought me to this work and why I co-founded Know Your 9. So for me, like for many people who do this work, this started personally. I was raped and stalked while a student in college, and it changed everything about my experience on campus. I was afraid to leave my dorm. I was afraid to go to our one dining hall because I was worried about seeing him. He would confront me on campus. And so eventually I reported to my campus dean, and my dean encouraged me to take time off, go home, take care of myself, and just sort of come back to school after my abuser had graduated. And I did that. I left that semester right in the middle of the semester and went home. And it was only by sort of a chance meeting with the attorneys at the Victim Rights Law Center, who are really wonderful, that I learned that I had rights under Title IX, that not only did I have a right to stay on campus and feel safe, but that my school had an obligation to provide me all the sorts of accommodations that Lara has talked about. So helping me switch my classes and my dorm, and making sort of all the different adjustments so that I could feel safe going to school. So I eventually did return to school with the help of the Victim Rights Law Center. But even in that process, once I finally did have campus administrators telling me that I could stay on campus and that I could receive certain services and accommodations, even then I wasn't told that the types of services and accommodations that were being given to me were required under the law. And I know that might seem like a minor distinction, but it was actually really transformative for me when I learned that my school wasn't making these adjustments sort of out of the charitable goodness of its heart, but that these were obligations and rights to which I was legally entitled. And so when I returned to campus, I started talking to survivors at my school, and we started organizing to change policies on our campus. So we started out, like a lot of students on a lot of different campuses, by meeting with administrators and presenting a list of our concerns and proposed policy solutions to change them. These were, in our minds, very low-hanging fruit and very concrete asks that should not have been difficult for the school to accommodate. But unfortunately, they largely stonewalled us and ignored us. And so eventually we took our fight public, and a survivor named Angie Epifano at my college published a very lengthy account of her experience after her assault, specifically with the administration, and that went viral. And that effort really drew the media spotlight onto my campus and created the political will not only among students and faculty, but especially among administrators and the president of the college to finally really address this issue. And so I think that it might be a little, I know we have a sort of a wide variety of folks on the call, so I hope that my comments can be helpful to the diversity of people who are here. But I thought one place where it might be helpful to start would be talking about the different tactics and strategies that students and survivors are using to make change on their college campuses. So as Lara said, a number of survivors are filing Title IX complaints with the Department of Education against their universities. But that's really just one strategy of many, and it's often one that survivors choose to accompany a variety of other tactics. So at my own college, after we had tried meeting with administrators, we largely used art and performance to highlight our experiences. So we published a magazine called It Happens Here, which documented the experiences of survivors and their friends on campus, and in particular, their interactions with sort of the bureaucracy of the Title IX office. We also, trying to figure out how to advance, there we go. We also created a photography exhibit called Surviving at Amherst, in which survivors sort of told shared the words that administrators had said to them when they tried to report. Those images, as well as Angie Epifano's story, really did go viral, and again, that was a really key strategy for us to finally get the attention that we needed from our peers and from our school. Other students are using different tactics. Students at the University of Kansas last fall became really upset when they learned that their school wasn't really punishing rapists, and so they launched a really significant social media campaign to highlight their school's abuses. At Syracuse University, also in the fall, students staged a sit-in for several weeks, occupying their university's administrative buildings after the institution had abruptly cut their sexual assault advocacy center and other support services. One thing that I think is really particularly powerful about the work going on at Syracuse is its focus on the intersections between a number of different acts of violence and institutional neglect on campus. So they were, not only protesting a lack of support services for sexual assault survivors, but also a lack of services for survivors of color, for queer and trans students, and for students of color more broadly. At Brown University, among many other actions, students chose to wear IXs on their graduation caps, representing Title IX, of course, which is a really powerful display. And then, of course, at Columbia University, Emma Silkowitz has very famously been carrying around her mattress as part protest art and performance art. Another really powerful tactic at Columbia is the creation of an alumni fund. This alumni fund basically encourages alums to donate their money to the fund, which funds sexual assault organizing efforts in place of donating to the university. So it's a really interesting and creative way to allow supportive alumni to invest in campus organizing and student activism rather than the university bureaucracy and legal PR apparatus. So I think what all of this shows, among many things, is that students are really claiming their civil right to be safe on campus. It's civil rights that they're largely focused on rather than an effort to reform the criminal justice system, although other students are certainly doing that work in smaller pockets. But as state legislators, some of you may be aware, as state legislators are proposing bills that would effectively make receiving Title IX services contingent on reporting to the police. I think it's really crucial that we remember that survivors are asking for more options in reporting, not less, and that for many survivors, going to the police isn't even a particularly viable or attractive option. So students and alumni are obviously using a real diversity of strategies and tactics to change their schools. And they aren't all asking for the same thing, of course. It's important to remember that every campus community is different, and the problems, while generalizable, certainly are rooted in sort of specific experiences on specific campuses. But I thought it would be helpful to talk next a bit about sort of the common threads running throughout students' concerns and their activism. So here are some of the things that I think student activists are or can be asking for, and sort of on the flip side, the things that school administrators should be doing proactively. So the first is informing survivors about their rights and clearly explaining that these are rights guaranteed under law rather than, again, bestowed out of the charitable goodwill of the college. I know this might seem like a small, very nuanced point, but I don't think it is. From the perspective of a survivor, it really helps shift the gross power imbalance between student and institution by demonstrating quite clearly that the law is on the victim's side. So this means proactively educating survivors about their rights, including their rights to retake classes without academic or financial penalty, designating a staff person to assist survivors in obtaining extensions on academic work from professors so that the burden doesn't fall on survivors to explain. I'm also noting the time and that we were running out, so I will try to speed through this quickly. Another thing that's really critical that schools are doing are anticipating the financial barriers to safety and educational access that survivors might face. So that could be anything from the cost of transportation to and from court for a civil protection order, STI treatment, medical expenses, counseling services, academic tutoring, alternate housing if the survivor needs to switch dormitories, and course change fees if a survivor needs to withdraw from a class for some reason. And that's just to name a few. So Title IX obligates schools to remove gender-based barriers to education, and a school should accordingly be looking to address the financial barriers that are consequences of gender-based violence in school. I will speed through the rest of these so that everyone has time for questions, but it's important that schools ensure that their policies are responsive to the needs and experiences of survivors of all genders, as well as survivors of all forms of gender-based and sexual violence. I think that the experiences of dating violence survivors and stalking survivors sometimes get left out of this conversation, and there are really specific adjustments and remedies that schools can make to support DV survivors that might not be obvious. So things like making it clear that a domestic violence survivor won't suffer academic penalties for missing class to secure a civil protection order, or schools not publishing students' on or off-campus addresses online without their consent. Those are just a couple examples. And of course, those two goals can be best accomplished by drawing on the lived experience and expertise of those who know best survivors. So I always strongly encourage schools to center survivors in their school's policymaking process by including survivors on the committee that's rewriting the sexual misconduct policy and actively seeking survivors' input on the areas of policy and practice that aren't working or could work better. Finally, please invest in community support services. There are many really incredible rape crisis and domestic violence advocates doing really amazing work, as well as legal advocates. And I think it's really critical that when schools are responding to student activism, that they are investing in those community services rather than sort of bulking up their own PR structures. I'm sorry for speeding through that. I hope that was helpful, and I will turn it over now to Amanda and Lara.
Thank you so much, Dana, and Lara as well for both of your great presentations. We have just a few minutes for questions. Just as a reminder before we go into the Q&A, we have recorded today's webinar, so we will circulate a link with the webinar recording as well as the PowerPoint slides within the next few days. I have a question for Lara. Is there a statute of limitations on filing a Title IX complaint?
Yes, and I appreciate the question because I did mention the time limit for filing an OCR complaint, but I did not mention the time limit for filing a complaint in federal court. The way it works is whatever the statute of limitations is in your state for personal injury actions, that's the statute of limitations that applies for Title IX purposes. In some states, it's 2 years. In some states, it's 3. I think there may be a couple of states where it's longer than that, and there may be a couple where it's shorter. So folks should check with experts on state law in their area, or you may even be able to find the answer to that online.
I think this is a question for both of our presenters. Are there examples of colleges or universities who are doing it right, who are handling things in the way that you'd like to see them handled?
That's a great question, and I will let Lara hop in to answer this. I found that whenever I name a school that I've heard is doing it right publicly, then I always get a stream of emails from survivors at their school that say, no, my school is not doing it right. So I always try not to answer that, but Lara may have some helpful suggestions.
You know, I don't have a great answer, but you know what I would look to if you're looking for models on how to do it well? I would look at resolution agreements that OCR has entered into with some of the schools that they found were doing it wrong, and see what kinds of things OCR is asking those schools to do in order to get it right, because that'll give you a roadmap of steps that your school can take. Some of the things, for example, that OCR is requiring schools to do is school climate surveys, anonymous surveys to students on a regular basis, maybe annually or every 2 years, where you ask a series of questions about the climate on campus for students. You get a better sense, because it's anonymous, of how many students are experiencing sexual assault. And you also can ask questions about the effectiveness of your prevention training. You can ask questions about whether people are aware of the grievance procedures and what they think, you know, have they availed themselves of them, and what have they found them to be satisfactory, user-friendly. You know, do people know who the Title IX coordinator is? With surveys like that, you can really get a good sense of what's going on your campus and where you need to improve. Also, some of the other things being required are the appointment of a confidential person on campus to whom students can report confidentially and access services without any fear that it's going to be shared. And you know, anything you can do to encourage reporting is good. So I think making sure that students know who that person is and that that person is accessible and has good training and has resources and places to refer students is really important. So I would look at some of those resolution agreements. There are a number of them now, and they're all available publicly.
Thanks, Lara. This is a question for Dana, but Lara, if you have something as well. How can people find programs to help educate staff and students on campus? Are there resources out there that you can share? And if there are, I can include them in the follow-up resources that we send to people who are on this webinar.
That's a really great question. And you know, I don't do a lot of, my work hasn't really focused a lot on sort of the types of good bystander education programs out there. But I know that those do exist, and I think that the Department of Justice's Office on Violence Against Women may compile those or could pass those along. Lara, are there any that come to mind? I've heard good things about the Green Dot program.
And I don't know as many specifics. I would send people, I think, to notalone.gov. Wouldn't that have access to some of those resources? I know the Department of Justice is putting together some, you know, best practices. I don't know if that's out yet, though.
Mm.
Okay. Is there another question?
Yeah. Is there anything different in cases of assault where both the victim and the assailant are the same gender?
No, it's not a different analysis at all. You can certainly be assaulted by someone of the same gender. You can certainly be harassed by someone of the same gender. And if it meets the definition of harassment or assault, then it makes no difference.
Thanks, Lara. We are a little over time, so I'm going to turn it over to our presenters at this point if there are any last thoughts or things that you want to offer or share or address at this point.
Thank you, Amanda. You know, I just want to reiterate that this is an issue. We talked a lot today about campus sexual assault and what's happening on college campuses. It is an issue that's affecting K-12 students as well, and there are cases, as I said, that we're litigating that that are cases of K-12 students who were assaulted in school, but also, you know, we are encouraging the administration and others to put out materials out there that will be useful for folks at that level as well. And if people have questions or need more information, they should feel free to contact the National Women's Law Center. Dana, do you have anything else?
Just to continue a bit in that vein, I think that a lot of the media attention of the past year has focused on a very particular type of college and university. We're hearing a lot about the Harvards and Yales to the exclusion of other schools where this is happening, so community colleges, HBCUs, other schools. And so I think it's important, sort of as we're thinking about the impact on K-12 survivors, to also think about the impact on survivors at many different schools.
Absolutely, absolutely. That's an excellent point. And we really want to thank everyone for taking the time out of their busy schedules to learn more about this, and we encourage you to stay connected, and we will be following up with information in an email. So thank you very much, and have a great day.
Great. Thanks, Lara, and thanks, Dana, again for your great presentations. Thanks to everybody for joining us today. Our contact information is up on the screen, and as we've mentioned, we'll circulate all of this information within the next few days. So please keep an eye out for that email, and thank you all for joining us today.